Good afternoon, Chair and members of the committee. I'm here to present AB 2282. Many parents in the family regulation system have suffered from the mass incarceration trend. The statistics show that 11.4% of African American children and 3.5% of Hispanic children have an incarcerated parent. It is not uncommon for parents in dependency court to have a conviction for offenses defined as a violent felony, which include robbery and carjacking. However, many times a parent's criminal history has no current bearing on child safety or parenting ability. I believe that after we sentence people to go to prison, they've paid their dues. They've served their time, and that is what they're supposed to be rehabilitated. So when they get out of prison, we should enable them to go to the courts, go through the system, and request and try to get their children back. Last year, I passed AB 937, which gives a person 24 months to go through the system and to get their children back. And so I think that we should allow people coming out of jails, coming out of prison, to go through the same system to get the 24 months to get their children back. And we should allow the judge to say if they can have their children back or not. We should not limit them from seeking their children. So AB 2282 would limit criminal convictions used to deny reunification services to families in the family regulation system. It would amend the law to deny services only to the most serious and violent felons who've endangered children. This reflects the safeguards taken by almost every other state regarding reunification for a parent with a violent criminal history, preserving the safety of the child and the family unit. Here with me today is Julia Hannigan with Dependency Legal Services and Fidel Shigoa.
Thank you.
Honorable Chair and committee members, thank you for your time. My name is Julia Hannigan, and I am the Policy Director at Dependency Legal Services. We represent parents and children in child welfare proceedings in Northern and Central California. We are proud to support amending the felony bypass statute to encompass only violent felonies that involve a child. In terms of child welfare, the termination of parental rights is often described in case law as the death sentence for parents in dependency court. And in that context, the bypass statutes often mandate that parents are swiftly sent to this death sentence without an opportunity to prove that they can safely create a home for their children. It means families are immediately put in a position to be permanently separated. This bill limits the families that will be forced into that predicament. It focuses on bypassing only parents who have convictions that involve a child. That would put California in line with what much of the country already does. We believe in narrowing that focus makes sense in the child welfare system, which should only be focused on the risk of harm to the child. We do want to be clear. This bill does not mandate return to parents who are still a danger to their children, nor does it require immediate placement with parents with these serious convictions. Instead, it requires the court to give parents the opportunity to show that they can make a safe home for their families. We believe this change benefits both our minor and our parent clients. It gives our child clients the full and fair opportunity to grow up in homes with their parents if it is safe to do so. It also allows our parent clients the chance to make the changes in their lives and become the parents that their children deserve. As a result, we respectfully ask for your aye vote.
Thank you.
Good morning, Honorable Chair and members. My name is Fidel Chagoya. I currently work with Starting Over, Inc., which is a nonprofit organization, as an organizer for Riverside All of Us or None, that works on helping formerly incarcerated people obtain housing, employment, and getting record expungements as well. I'm also a grad student at the University of Redlands in clinical mental health counseling, finishing up my master's program. I'm speaking with you today because I'm a formerly incarcerated person that has been out for already over 14 years. I got a certificate of rehabilitation through my transition. My daughter Zoe was born in 2016 when I was 39 years old. At that time, I had been out of prison for 6 years and off parole for 4 years, and had managed to find steady work, housing, and transportation. During childbirth, Zoe's mother tested positive for opiates that was prescribed for Tylenol with codeine that a dentist prescribed her. This triggered the involvement of San Bernardino County's Children and Family Services, who looked at my past criminal record and said I should not have an opportunity to even reunify with my child due to Welfare Institution Code Section 361.5B12, which is the bypass provisions. My parental rights were terminated, and in 2019, my daughter Zoe was adopted out with 119 other children in San Bernardino County. Because of my prior criminal history had no bearing on whether I would be a good parent or not. If this change in law proposed by AB 2282 existed at the time of my case, I would have had a fair chance of reunifying with my daughter. I am here for you to consider making sure that parents like me who have felonies unrelated to their ability to be a parent, and in many cases have paid their debt to society, a fair chance of getting their children back. For these reasons, I express my support for AB 2282. Thank you, Chair and members.
Thank you. Is there anyone else here in support of AB 2282?
Good morning, Chair and members. Jeronimo Aguilar here, Policy Analyst with Legal Services for Prisoners with Children. Proud co-sponsor in support of this bill. Also, on behalf of All of Us or None, our statewide chapters. Much love, Brother Fidel. Thank you for this.
Thank you.
Brooke Hewley, Los Angeles Dependency Lawyers, proud co-sponsor.
Thank you. Is there anyone here in opposition to AB 2282? Seeing none, we'll bring it back to the committee. Any questions, comments, motions? We have a motion and a second. Vice Chair Dixon.
Thank you, Chair. I really hear your comments and have great sympathy and sadness for you. I just want to clarify, not to, just apart from the emotional, because it is very important, but will the judge still have, will the court still have discretion? Could you
Yes.
clarify that for me, please?
Yes, the judge will still have discretion, and they will still have to go through what anyone else would have to go through to get their children back. And so they would have to go through the 24 months with the social worker, and then they would have to go before the judge. So they wouldn't just get their children back, but they would have the opportunity. Because as we know, when we send people, this is what the law's saying, and is what we think in California and in this country. As we send people to prison, we send them there to rehabilitate. When they come out, they should have the same opportunities as the rest of us have. And so this would only give them an opportunity to get their children back. They wouldn't be handed the children.
Okay, and did I read somewhere in the bill or in the analysis that when the child welfare, what is the position of the child welfare organization? Have they taken a position in support of? They're neutral.
Yeah.
I thought I read in some analysis that the reunification, during the reunification process and the interview process, that the meeting between the child and the parent cannot take place under supervision.
That was a prior bill, but yeah, that was the bill prior to this from someone
that's
called
another
around.
bill.
It's a different bill, yeah.
Different
Okay.
They have similar
All right.
ideas in
Thanks,
there.
Susan.
So.
Okay, my apologies.
Yeah,
Okay.
no problem.
No further questions, and thank you.
Thank you.
All right, we have a motion on the floor, and I want to thank the author for bringing this forward. Actually, in a similar vein to the prior bill we heard, like our goal should always be reunification and what's in the best interest of the child, as long as there are safeguards for when it's not appropriate. And that's what we have here. We have a judge that's going to make the ultimate determination. But if we believe in healing, if we believe in restorative justice, if we believe that people aren't defined by the worst thing they may have done in their life, we should also appreciate that children are best off when they're with their parents. And parents should have the opportunity to at least make the case, especially in the same, under the same rules and under the same guidance and protections that all parents that are trying to reunify have to go through. And so I really appreciate you, Senator McKinnon, for bringing this forward. I think it's a bill that has the appropriate safeguards, but ultimately leads us where I think everyone that supports families should be, which is having children be with their parents. With that, would you like to close?
Yes, I would like to thank Fidel for sharing his story and let you know that we're so very proud of you. This will help formerly incarcerated parents retain the positive family relationship that reduces recidivism. I respectfully ask for your aye vote, and I apologize for the tears, but that's just me. Sorry.
I was once crying in chambers when I was a public defender, and because a client of mine was going to get a pretty heavy sentence, and I was apologizing to the judge as I was trying to make the argument to the judge as to why that shouldn't be the case, and the judge said to me, "You should never apologize for being human." So,
Thank you.
Madam Secretary, if you can take roll on AB 2282.
Motions do pass to Human Services. Cholera.
Aye.
Cholera, aye. Dixon. Ting. Bryan.